Hey guys and gals, this is the Bar Exam and Chill podcast. I'm your host TJ. Today we've got a hypo from the July 2019 California Bar Exam. This is applicable to the UBE, so don't worry, we're in federal standards. Let's go down, and before we read the hypo, practice reading the questions first, see what they tell us, what kind of question we're going to be into today. So question number 1 here. How should the court rule on Priscilla's motion to compel further responses to her interrogatories to Grocery? Discuss. Question 2. How should the court rule on each of Grocery's motion to compel? Discuss. Question 3. Was Grocery's response to Priscilla's interrogatory about its expert proper? Discuss. And question 4. Should the court sustain Grocery's assertion of privilege with regard to Xavier? Discuss. All right, so hopefully the questions are pointing you to this being a civil procedure essay. We're in the Rule 26 discovery area of the law. We've got some motions to compel here, and we kind of want to look at who are our people. We've got Priscilla's motions to compel, Grocery's motions to compel, and lastly, it talks about Grocery's assertion of privilege with regard to Xavier. So you want to keep in mind you've got these 3 people we're looking out for. We're probably in a civil procedure essay. It sounds like the questions will point you to, give you a little information for what kind of facts you might want to be highlighting as you go through the actual hypo. And let's get into it. In 2015, Priscilla was shopping at Grocery when a very large display of bottled soda products fell on her, bruising her head and entire body. She filed suit in federal district court against Grocery for negligently maintaining the display and sought damages for medical expenses, pain and suffering, and lost wages. Grocery recognized that jurisdiction was proper and filed an answer denying liability. Accompanying the complaint was a set of 26 interrogatories, which read in part, this is 25, please provide the names and addresses of every Grocery employee who worked on construction of the soda display and every soda company employee who did so. Interrogatory 26. Please provide copies of every training manual Grocery has used in training its employees. Grocery responded, objection. These interrogatories are flawed. Upon receiving the reply, Priscilla filed a motion to compel further responses. Grocery made 2 discovery requests asking for A. An order requiring Priscilla to submit to mental and physical examinations, and B. All of Priscilla's tax returns since 1995. Priscilla opposed both discovery requests, and Grocery filed motions to compel. Before Priscilla filed her lawsuit, Grocery hired Xavier, an expert on grocery store displays, to investigate the accident. His findings were unfavorable, and Grocery has not identified Xavier as a witness. Xavier is an independent contractor, but he works exclusively for Grocery. Included in Priscilla's original set of interrogatories was a question seeking the names and opinions of all experts Grocery had hired for the litigation. In response to that interrogatory, Grocery replied, objection, privileged. No information about Xavier was disclosed by Grocery. Bang, and then we're in our 4 questions here. So, seems like a pretty straightforward one. Let's get into question number 1. This is asking us about Priscilla's motions to compel. This is on interrogatories 25 and 26, which we have. And let's just go one by one, right? I would start here with interrogatory 25. What's our issue here? Issue. Can Grocery object to providing names of employees involved in the display construction? Rule. We're in Rule 26 of the Federal Rules of Civil Procedure, and we're going to see what is the scope of discovery that allows. Well, we've got to know 2 prongs basically here. In the Federal Rules of Civil Procedure, discovery is allowed for any non-privileged matter relevant to a claim or defense, and it has to be proportional. We might add on here the rule that the identity of witnesses with knowledge of the facts is explicitly discoverable under the rules. Let's apply that with our analysis here. Priscilla is seeking what? So we kind of come up here, Priscilla's first interrogatory, or 25th interrogatory rather, the first one that we're given, interrogatory 25, please provide the names and addresses of every grocery employee who worked on construction of the soda display and every soda company employee who did so. All right, well, is this relevant to a claim or defense? Well, she's claiming that she was injured by this soda display falling. So the witnesses that actually were involved in the construction of that soda display are directly relevant. And it seems pretty proportional here because it is just seeking those employees that worked on that specific display, not really anybody else. So we've got our two prongs here. It looks like it's relevant to a claim that Priscilla's making, and it seems pretty proportional. So our analysis is going to be Priscilla is suing for negligence regarding the display. The people who built the display are primary witnesses to whether it was built safely. It's highly relevant, seems proportional. Therefore, our conclusion, the court will likely grant the motion to compel. We might want to put in here something about, the groceries objection here. The groceries objection is simply objection. These interrogatories are flawed. It doesn't say why they're flawed or on what grounds the objection is made. So it doesn't really seem like the objection is going to be useful. And the court will likely compel the discovery. Nice and straightforward. Pretty easy for our first thing there. And let's go into the second one here, the interrogatory 26. This is seeking the training manuals. So our issue is the 26th interrogatory valid, and can the court compel that discovery that Priscilla is seeking? Our rule is that in the FRCP, this is specifically interrogatories are FRCP 33, it limits interrogatories to 25. So that's our rule. Again, we might restate discovery must be relevant to a claim or defense and proportionate to the needs of the case. So we would come into the analysis and say, well, Priscilla is seeking 26 interrogatories here. We don't have any facts stating that there's a proper basis for her serving more than 25. It looks like she just did that and then sought to compel. If you want to seek above 25 interrogatories, can you do that? Yes. And this is going to come up a lot in practice. If you're in federal court, this is really a very common thing that's discussed between opposing counsel at the outset of the case. Basically, you make your initial disclosures and you kind of say what discovery is going to be needed, and typically you're going to try and either stipulate to more than 25. Maybe the opposing counsel would say, hey, I don't want to do more than 25, in which case you're actually going to seek leave of court and you're going to need to justify why you're seeking more than 25. Typically, you're going to say something like, hey, look, this case is more complex than 25 interrogatories would allow, and we're seeking, more information than that. So we don't have in our facts here that there was any kind of stipulation process, and it doesn't say anything about like a motion was filed to try and seek above that. So we're just assuming here, based on the facts, that Priscilla just served these 26 and then moved to compel on the 26th one, which is at issue. So we've got our issue, we've got our rule statement here. It's limited to 25. We'd apply it to the facts here. Priscilla sent 26 questions, because it's strictly limited to 25 and we don't have anything that they stipulated that there was leave of court granted for this extra interrogatory. It seems like that's going to be fatal, and the court is not going to compel on this 26 interrogatory. Grocery can technically object to the 26 here because it exceeds the limit, right? Basically just says it's flawed. I mean, it doesn't really say on what grounds, but technically it is flawed here, right? Because there is a 26, it's above the limit. And we might even analyze, like, is this proportionate? Well, let's see. She's seeking 26. Please provide copies of every training manual grocery has used in training its employees. Now, this would be like training manuals for totally irrelevant stuff, right? How do they train their employees to scan items at the checkout counter? How do they train employees to stock shelves in the back of the store? This would be totally disproportionate, it seems like. So we've got two issues with this discovery response, or this discovery that is being sought by Priscilla, right? It goes above the 26, and it totally seems disproportionate to the actual needs of the case. She's got this one display that fell on her. She's seeking training manuals for everything. So it seems like the court is going to be conclusion, deny the motion to compel. It exceeds the numerical limit, and it's disproportionate to the needs of the case. So it looks like that's pretty straightforward for interrogatory 26. Looks like it's going to be denied for those reasons. Nice and straightforward. Let's go into question 2 here. This is on Groceries motion to compel. They're seeking a physical and a mental exam. So you would want to go through each one. Physical examination. What's our issue? Should Priscilla be forced to undergo a physical exam? What's our rule? If we're going to seek an exam, we've got 2 prongs we need to know. Number 1, the condition has to be in controversy in the case. And number 2, good cause must exist. So you kind of want to have in your mind, you want to remember that if you're seeking to compel like a physical or mental exam, you have these two problems you got to analyze under. Is the condition in controversy in the case? Is it actually being brought up and it's being litigated? And 2, does good cause exist? Let's apply it to the facts here. Well, Priscilla alleged that she was bruised, right? It says that she was bruised, so there is a physical injury, and she's seeking damages for medical expenses and pain and suffering. So is it at controversy in the case? Yes, she's put her physical injury at controversy in the case. She's seeking damages, and it's due to this physical bruising that happened when the display fell on her. So by claiming physical injury, she's putting it at issue in the case. We've got that first prong. Does good cause exist? Well, Grocery is going to want to know to what extent of liability they're facing, right? What kind of damages would they be on the hook for if it's found that they were negligent in this case? They want to know. I mean, was it like she can't use her arm anymore? It's totally fucked. Or is she, it's just like basically a little tiny little bruise that she's seeking damages for? That's going to be directly relevant to how the case proceeds. So it seems like good cause exists for them to want to know what is the extent of the physical injury here. So we've got our 2 prongs. Looks like they're fulfilled. Therefore, conclusion, the court will grant Grocery's motion to compel. Boom, bang, bing. We are good on that one. And you would just move into mental examination. So what's our issue? Well, should Priscilla be forced to undergo a mental examination? Mental examinations are... The court doesn't really want to grant mental examinations. That's pretty heavy privacy that you're invading. You're really getting invasive if you're seeking somebody's their mental state and condition. So here you've still got those 2 prongs. Is it at controversy in the case, and does good cause exist? We might want to note that for a mental examination, the standard is probably going to be a little bit higher than the physical examination. So what's our analysis? Well, Priscilla is seeking pain and suffering. And that seems like it's kind of just garden variety damages that she's claiming as a result of negligence. So you'll see when you plead a complaint, typically at the end you put the relief sought, right? So in a negligence case, you would have what's called garden variety emotional distress claims. That's just saying like as a result of this negligence, I suffered some emotional distress. And then typically you might also plead a separate cause of action for intentional infliction of emotional distress or negligent infliction of emotional distress. If you're pleading intentional infliction of emotional distress, you're basically saying like, hey, this was like malicious and it really fucked me up. There's some serious stuff going on. There's a distinction to be made between those in the law. And this comes up very frequently. If you're seeking to compel a mental examination and the person has just pled garden variety emotional distress, the court is not going to want to compel a mental examination because it's not really seen as serious, right? It's just sort of garden variety. Whereas if you've actually pled IIED, you probably can get, you can go seek leave of court and get a forced compelled mental examination. This happens in practice a lot. I mean, you'll run into this pretty frequently. That's the distinction to be made. So again, we would just sort of restate our rule statement here. Is the condition put at issue in the case, and does good cause exist with that heightened standard for mental examinations? Here, because it's garden variety emotional distress, it seems like the condition may be at issue in the case and that is brought up there, but good cause probably does not exist because the court is going to want to protect the privacy of the plaintiff here a little bit. And just because it's this just garden variety emotional distress, it's likely that the court is going to deny a mental examination unless, she's pled some kind of IAD claim, which here in the facts, we do not see that she has like a separate cause of action that she's put at issue. So on the facts that we have, it looks like the court is going to deny the motion to compel a mental examination for the reasons that we've just stated. Woo! Nice. This is all very common. I mean, if you're practicing in the law, you're going to be in discovery for the bulk of the lawsuit, and this kind of stuff is going to be super routine. You're going to, it's kind of hellish in discovery. This is typically what lawyers dislike the most about litigating is you get into all these motions to compel. It's probably worth mentioning, by the way, that if you do want to file a motion to compel with the court, it is absolutely critical, and you will be sanctioned if you don't do this. You have to do the meet and confer requirements, which in each federal district court, they'll have some under the local rules, they'll have exactly what you need to fulfill the meet and confer requirement. We might want to point out in our essay here, let's go to the facts. After the interrogatories, it just says, she served blah, 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 25-26. And then it says, Grocery responded, objection, these interrogatories are flawed. Upon receiving the reply, Priscilla filed a motion to compel further responses. So we may want to point that out. I mean, it may be that she can't get anything that she wants because she didn't follow the meet and confer process. And we probably want to point out, look, you're going to have to follow the meet and confer process before you seek intervention from the court. The court dockets are just insane, and everybody, wants to file motions to compel. This happens all the time in litigation. So the court doesn't want to get the docket all clogged up with disputes and discovery. So that's why they make it pretty burdensome. I mean, in the Central District of California, they have an enormous, they actually put down the number of days. You have to send a letter, basically like a meet and confer letter to the opposing counsel. They have 10 or 7 days or something to respond, and then you've got to come back in 10 or 7 days, have a joint stipulation all laid out. You got to go through a lot of rigmarole before you can bring one of these motions to compel. So we kind of want to point out it seems on the facts that maybe there was no meet and confer process. She basically just got the responses and immediately filed a motion to compel. Probably good to point that out. But here on the analysis of the mental examination, it looks like they're going to deny because maybe no good cause exists. The mental state is not really put at controversy because she's seeking garden variety emotional distress. That's pretty typical. So it looks like that's going to be kind of our answer there. Let's move in to maybe we want to discuss, I guess, how would you get one of these mental exams, right? How do we establish this? Like I said, if you've got an IIED claim, the court is going to be more willing to actually compel a mental examination. But what kind of factors does the court look at? We might want to put this in here. This might be a little bit above what we need, but it would look for a specific cause of action pled like IIED, to distinguish it from garden variety emotional distress claims. Might have if there was an allegation of a specific disorder, like you said, after this display fell on me, I was diagnosed with bipolar disorder as a result of whatever. I have PTSD from the display falling on me. Every time I go to a grocery store, I live in fear. It's absolute hell. And because of my PTSD, right? If you're actually claiming a specific disorder, then the court will look to that and say, look, we do think the defense is going to be entitled to having a mental examination to explore how serious is the PTSD and is it as a result of the display falling on top of her? Can you link that causation with the actual disorder? Here, we're not given any specific disorder. It's just saying that she had, as a claim for relief, basically pain and suffering. And so it looks like it's not going to be enough here. Just, we don't have a specific disorder. You might want to discuss that. Or if there's an unusually severe distress, which again, this seems like garden variety claim for relief at the end of a complaint. So, the other thing, by the way, is ongoing injury. You're going to see people ask this in depositions or in written discovery a lot. If you are claiming some kind of distress is ongoing, do you still suffer from it? That can be a relevant inquiry as well. So we've got those factors there for would the court compel a mental examination. We could go through them on exam day. And here it looks like the court is not going to compel a mental examination for those reasons. All right, so we've got moving into question 3. This is regarding Grocery's motion to compel the tax returns. So our issue is, can Grocery get all these tax returns all the way back to 1995? And again, we're just going to restate that rule. What is the scope of discovery under Federal Rules of Civil Procedure 26? Well, it's got to be relevant to a claim or defense, and it's got to be proportionate to the needs of the case. Here is her income relevant? Well, yes, because she's seeking lost wages. That's given to us in the facts right up top. So if you're seeking lost wages in a lawsuit, your income is going to be directly relevant. They're going to want to know, like, well, if you lost wages, what were your wages? I mean, if you were a really high earner, you're going to have more damages. So it seems like we've got relevance here. Is it proportionate to the needs of the case? We're given here in the facts that the accident happened in 2015. These are seeking tax returns all the way to 1995. That's 20 years of income data. It seems like that's going to be wildly overbroad and not proportionate to the needs of the case. I mean, the lawyer here is obviously just being kind of a dick, right? He's just like trying to make it as burdensome as possible. I mean, that's why a lawyer would be doing something like this. It's hard to get your tax returns. Do you keep your tax returns all the way back from 20 years ago? Maybe, but if you don't, right, and they kind of use this, they could use it as a cudgel to beat you over the head and be like, hey, you don't have your 20 years of tax returns, and then they could try and use it against you. So that's why someone would do something like this. This is pretty common discovery dispute. So here our analysis is going to be, again, Priscilla seeking lost wages, therefore it's relevant. Is it proportionate? No, it's seeking 20 years. So the court is going to have, discretion here to probably, they're likely the court will deny it as written. They're not going to compel all 20 years. As part of the actual process when you're arguing, a judge would likely in court be like, hey, can you seek just less than the 20 years? The court might unilaterally just say, we're not going to give you all 20 years, but we will compel a reasonable or proportionate number of years of lost wages, of your income, of your tax data. Typically, that's going to be anywhere between 3 and 5 years. That seems to be kind of what would be seen as reasonable, I guess. So our conclusion here might be that the court is likely to deny the interrogatory as written because it's not proportionate. But maybe as part of the motion process, in the alternative, Grocery says, if the court cannot compel 20 years, we are fine with 3 to 5. If they put that in to oral argument or in a reply or in the motion or something as it was being litigated, then the court might actually compel a reasonable number of years to show lost income. That might be the most accurate conclusion here. So maybe you just put, hey, as a conclusion, the court is likely to deny as written because it's not proportionate. Awesome. We're moving right along. This is all super useful for practice here. So question 4, this is about this expert, Xavier. So we've got our issue. Can Priscilla compel the disclosure of the information regarding this Xavier? And was Grocery's response here proper? Well, our rule is going to be that a party must disclose and identify testifying experts. However, consulting experts are typically not required to be disclosed unless there are exceptional circumstances. So we'll want to analyze under this. That's our rule, right? If it's a testifying expert, then they have to disclose. Here, it's explicitly saying that this Xavier in our facts, he found information that was unfavorable. And the timing of when they when they retained and used this expert is going to be relevant. He could be, right, this is the work product standard. Under work product, if you retain somebody in anticipation of litigation, there's your Wingardium Leviosa, then it's going to be, protected. It's going to be privileged under the work product doctrine. They don't want, if you hire an expert in anticipation that somebody's going to sue you, they don't want the other side to just be able to, piggyback on your work and use everything against you. So that's kind of why they have this standard. So our rule is, again, we could state it. If it's a testifying expert, you got to disclose. If it's a consulting expert, you don't have to disclose unless there's exceptional circumstances. What are those exceptional circumstances? Well, I mean, if there's some kind of spoliation, or if this person is the only witness that even saw it, they took it down, destroyed it. He's the only guy that ever saw any of this crap. Nobody else can testify to it. Then you might have an exceptional circumstance where you would have to compel disclosure of that person, and they might be, deposed in the case. Is that what's going on here? We might want to do a little analysis. It gives us that Xavier is an independent contractor hired for litigation, basically. So it directly says that he's not going to testify. That's why they're not disclosing him. So he's not within that first prong. He's not a testifying expert. They're not going to have to disclose based on that grounds. if he's a consulting expert, your rule is basically you don't have to disclose unless there's these exceptional circumstances. So we might want to apply it here as, can Priscilla get this information from somebody else? If she can, then the court will not compel disclosure of Xavier. So, it does, as she said up in her first interrogatory, she's seeking all of the employees that helped set up the display. So there are other people that were involved in the actual setting up of this soda display that fell on her. There are employees for the store. There may be, people that were there that day. Priscilla also saw the display. So it seems like she can get this information through other means. It doesn't seem like Xavier's the only person that has any knowledge as to how the display was set up and what was going on in terms of safety. So it doesn't really look like we're going to have any exceptional circumstances here. It pretty much falls under that non-testifying status where you don't have to disclose. So we've got our rule, we've got our analysis here. Our conclusion is probably going to be something like, hey, Xavier is a consulting expert and he's probably protected under the work product doctrine. Therefore, the court is not likely to compel disclosure of Xavier. This may be one, right? You can always kind of argue both ways. I don't think the bar exam typically cares like what conclusion you come down on. People will go either way, depending on how you justify it. If you wanted to argue like, hey, it seems like they hired this Xavier guy and then afterwards they took the display down, he's the only guy, and so maybe there is some exceptional circumstance there. You could probably go with that conclusion, but again, I think it's probably not correct because you've got this interrogatory that Priscilla actually served where she's seeking the identity of these other witnesses that are going to have knowledge about the display and how it was set up. So to me, it seems like there's not really exceptional circumstances that would compel disclosure of this non-testifying expert, and that's kind of the conclusion I would reach here. Nice. So if we want to, the wording of the questions is important. Here it's asking us, should the court sustain Grocery's assertion of privilege with regard to Xavier? So as part of your conclusion, you're going to want to follow the language there. And you would probably say here, the court is likely to sustain. They are likely to sustain what? Well, they're going to sustain Grocery's assertion of privilege with regard to Xavier, because he's a non-testifying expert that was hired in anticipation of litigation. Those are your key words. Woo! Man, really straightforward discovery question. That would be an awesome one to get on the bar exam, I feel like. If you have those rules and those prongs under your belt, you're going to kill that one. Not really as difficult as that 100-mile bulge one we just did. That was a doozy. You don't want to get that bar exam question, so you just kind of have to pray to God. Please, God, give me a straightforward one like this. Just because we're in the realm of experts and testifying experts and so on, this is not a part of the essay question. We've answered all four of those. I think that would be a fair job if you went issue, rule, analysis, conclusion for each one of those and you answered it just as we did. I think that would be a killer bar answer. But just because we're in this field, I kind of wanted to talk about the other expert stuff that might be useful for you on the bar exam or the MBE. You've got, for an actual person that is going to testify, an expert that's going to testify at trial, the federal standard is called the Dauber standard. It comes from a case called Dauber versus Merrill Dow. And there's some Dauber factors, right? If you're going to actually have a expert testify at trial, there's a gatekeeping that's done by the court. They'll keep out experts that are, not actually qualified, basically. So what have you got here? You've got under Federal Rules of Evidence 702, there's a test that has to be satisfied. If you're going to have a testifying expert, I just want to go through these four elements for you so you know. So A, the expert has to have specialized knowledge that will help the trier of fact understand evidence or determine a fact in issue. Boom. B, the testimony has to be based on sufficient facts or data. There has to be some basis that they're justifying their conclusions on, right? And you want to go into that. C, the testimony has to be a product of reliable principles or methods. And the last one here, the opinion has to reflect a reliable application of those principles and methods. So that's kind of nice. You've got reliable principles and methods, and it has to reflect that you used those reliable principles and methods. Those kind of go together easily. So hopefully you can kind of just remember, well, the expert's got to have some specialized knowledge that will help the trier of fact. It can't just be Joe Schmo. If it's just any witness could testify to it and it's not specialized knowledge, then why do you need an expert? That's your first prong. Second prong, it's got to be based on sufficient facts or data. You've got to have reliable methods by which you're coming to your conclusion, right? And you've got to be using those. So awesome. Your Dalbert factors are going to be, it has to be testable and falsifiable. Okay, so just so you're clear, those four are under the Federal Rules of Evidence test for 702. Those are the elements you've got to satisfy. Now, under the Dalbert, you've got these Dalbert factors that were explicated in the court decision. Number one, it's got to be testable or falsifiable. Can the theory or technique be tested? Number two, peer review and publication. That's a pretty big one. Number three, it's got to have a known or potential error rate. So your expert has to actually say, like, what is the error rate? It can't just be, you can't just be pulling stuff out of your ass, basically, is what the court wants. Number four, there's got to be an existence and maintenance of standards and controls. That aligns with our sufficient facts and data and reliable principles and methods pretty well. And number five, there's got to be general acceptance in the relevant scientific community. So the federal courts are going to rely on the Federal Rules of Evidence 702 standards up there, and also these Dalbert factors. So if the question on the MBE or in an essay question is saying like, hey, we're going to try and get this expert to testify, those are the things you're going to want to analyze under. Those are your key words. And I will go through, right, for California, they have a separate standard. If you're not in California, you can kind of just tune out now because I'm done. We went through the questions. We went through the Federal Rules of Evidence and the Dalbert. That's what's relevant for the UBE. And also in California, you're going to have to know those. But you've got this specific Kelly-Frye standard in California. In state courts, if you've got an expert, you're going to have this other standard you got to be worried about when there is novel scientific techniques at issue. This is primarily the standard for novel scientific techniques or new methods of proof. And they give these examples, right? It's a polygraph, voice print, certain DNA methods when first introduced. If you've got hypnosis, they also do. I've seen that actually in a case for hypnosis. If it's on novel scientific techniques, there's this other standard you got to worry about. It does not apply to every expert opinion. That's what's clutch here. It's really just specifically these novel scientific techniques. For ordinary expert testimony, California is going to use the Evidence Code Section 720 and 801. What's our two-step process for Kelly-Frye here? This is frequently tested on the California bar exam. Number one, the reliability of the method. The proponent has to show that these new scientific techniques are generally accepted, so that aligns kind of with what we were talking about earlier, as reliable by a typical cross-section of the relevant scientific community. They want the person to be accepted in the scientific community, basically. They don't want some, like, quack doctor or quack loser idiot going off on stuff that's, like, not accepted by people that are respected in the field. They want to have some bar to get rid of those people so you're not misleading the jurors. You're not giving them a bunch of crap that's just not useful, right? So you got one, reliability of the method, and two, proper application in this case. Again, they go hand in hand. So these experts, you can kind of see these elements. Hopefully they're easy to remember because they kind of go hand in hand. If you remember one element, like in the Dalbert factor, you've got A, B, C, and D. C is testimony as product of reliable principles and methods. D is it reflects that you applied those principles. Those are nice to remember because they go hand in hand. Same kind of deal here on this Kelly-Frye standard. If you've got a novel scientific technique, you got one, it's got to be reliable, and two, you have properly applied that method in the case. Again, the expert has to be properly qualified. when you disclose your expert, you're going to put their qualifications down. And also, there's typically a requirement that you put down the actual rate that they get paid at for litigation. And you're going to see, whoa, it's good to be an expert. Holy shit, they get paid really well. I mean, if they get deposed for 7 hours, they might make, thousands of dollars. So you got to be, that can be kind of burdensome in litigation. The actual amount of the cost of the experts can be astronomical depending on how much the expert charges and how involved they are in the litigation. So those are some good things to keep in mind in your actual, for practice. And that's all I got for you today. That was a nice, straightforward, easy one, very applicable to practice. So all of this stuff that we learned today is going to be right in the meat of what you're doing once you pass the bar exam. This is going to be in the most important part of your practice is discovery, basically. When you get hired at a firm, you're probably going to get relegated to discovery first off, and you're going to be doing a lot of these, putting together motions to compel. And I'm just going to say you want to be very, very, very cognizant of what the actual standards are in the court you're in for meeting and conferring and actually bringing a motion to compel. You can't do it just out, right off the bat. Let's say you get questions or answers from the opposing counsel that are shitty. You're going to have to meet and confer with them. So it's probably good to point that out here. But we've gone through IRAC, we've killed this bar exam essay, we're knowledgeable, and we're going to pass. All right, I'll see you guys next time.